Welcome, my fellow tax professionals. This course is going to identify the offer and compromise application process with an emphasis on the offer and compromise application packet and the items that must be included therein. This course is also going to identify the three bases for offer and compromise acceptance. I hope you enjoy the course. The application packet for an offer and compromise request can seem like a confusing puzzle to tax professionals who are new to the offer and compromise practice. This video will provide guidance to help submit the correct documents to the IRS. IRS Form 656, Offer and Compromise, must be submitted to the IRS to start the offer and compromise process. No oral requests are allowed. Without Form 656, there can be no agreement between a taxpayer and the IRS to settle the back tax liability for payment of less than the amount owed. Form 433 must accompany Form 656. But this begs the question, which Form 433 is appropriate? There are many to choose from. In fact, the IRS has created special Form 433s just for the offer and compromise process. Form 433A OIC is titled Collection Information Statement for Wage Earners and Self-Employed Individuals. All individuals must submit this form along with Form 656. Form 433A OIC identifies the taxpayer's assets, income, expenses, among other things. Form 433B OIC is designed for businesses, including corporations and LLCs. Form 433B OIC is titled Collection Information Statement for Businesses. All corporations and LLCs must submit this form along with Form 656. Like Form 433A OIC, Form 433B OIC identify the business's assets, income, expenses, among other things. The taxpayer's first payment obligation is the application fee. Taxpayers seeking to compromise their back tax liability must submit a $186 application fee along with the offer and compromise application packet. This application fee cannot be labeled as a deposit or the application may be returned. The application fee will not be refunded to the taxpayer if the offer is accepted, rejected, withdrawn, or returned as unprocessable after acceptance for processing. This application fee is waived for certain low-income taxpayers and is not required for taxpayers seeking to compromise taxes based on doubt as to liability. The second payment obligation relates to the offered down payment, or sometimes called the partial payment. The payment is either a lump sum payment or a periodic payment and depends on which of the two payment plans the taxpayer chooses. Separate payment plans will be discussed in detail in other courses offered by National Offer and Compromise Academy. A lump sum payment offer, one that is payable in 5 or fewer installments, must be accompanied by the payment of 20% of the amount of the total offer. Alternatively, a periodic payment offer, one payable in 6 or more installments, must be accompanied by the payment of the amount of the first proposed installment, and additional installments must be paid while the offer is being evaluated by the Internal Revenue Service. Any taxpayer who seeks to compromise back taxes must identify the legal basis supporting his or her request on Form 656. The first basis for compromise is doubt as to collectability, and it's the exclusive focus of this website. Doubt as to collectability exists in any case where the taxpayer's assets and income cannot satisfy the full amount of the liability in one payment or through an installment agreement before the collection statute expiration date, or CSED. An offer to compromise based on doubt as to collectability generally will be considered acceptable by the IRS if it is unlikely that the tax can be collected in full and the offer reasonably reflects the amount the IRS could collect through other means, including administrative and judicial collection remedies. The second basis for compromise is doubt as to liability. Doubt as to liability exists where there is a genuine dispute as to the existence or amount of the correct tax liability under the law. Doubt as to liability does not exist where the liability has been established by a final court decision or judgment concerning the existence of the liability, because at that point, the debt is not in doubt. An offer to compromise based on doubt as to liability generally will be considered acceptable if it is reasonably reflective of the amount the IRS would expect to collect through litigation. The third basis for compromise is the promotion of effective tax administration. The IRS may compromise to promote effective tax administration where it determines that, although collection in full could be achieved, collection of the full liability would cause the taxpayer economic hardship. Economic hardship is defined as the inability to pay reasonable basic living expenses. No compromise may be entered on this basis if compromise of the liability would undermine compliance by taxpayers with the tax laws. Thank you for listening to this video, and please spread the word to your fellow tax professionals. The National Offer and Compromise Academy is available to help professionals expand their practice into the profitable area of offer and compromise. The music for this video was provided by www.bensound.com. You can contact the Academy from its contact page at www.oicacademy.com. Enjoy the online course and keep on learning.